Hello, everyone. So today we are going to go over a very famous Supreme Court decision from 1954. It is called Brown v. Board of Education of Topeka. It's a consolidation of cases, so there are multiple cases that this sort of decision is representing. That happens a lot in the Supreme Court, where if there are multiple laws that are very similar in different states, a lot of times the Supreme Court will rule on them sort of as a consolidation in order to sort of make a larger point about all of them. And this is one of those. So this is from 1954. And I'm going to read the decision and sort of kind of stop along the way and explain. Hopefully you've had an opportunity to already look at this. If you have not, then this is a great opportunity to sort of look at it with me. And I'll kind of explain as we go some of the things that Chief Justice Warren is sort of explaining, he's mentioning, but also I think this is really important to see sort of what he does not talk about. And so I'll just start and we'll sort of stop and discuss. So this is just an excerpt, and let's begin. These cases come to us from the state of Kansas, South Carolina, Virginia, and Delaware. They are premised on different facts and different local conditions, but a common legal question justifies their consideration together in this consolidated opinion. So there he's obviously explaining exactly what I just said, that it's these multiple states, Kansas, South Carolina, Virginia, and Delaware, but that this is a consolidated opinion that they're going to rule on. In each of the cases, minors of the Negro race, through their legal representatives, seek the aid of the courts in obtaining admission to the public schools of their community on a non-segregated basis. In each instance, they had been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. This segregation was alleged to deprive the plaintiffs of the equal protection of the laws under the 14th Amendment. In each of the cases, other than the Delaware case, a three-judge federal district court denied relief to the plaintiffs on the so-called separate but equal doctrine announced by this court in Plessy v. Ferguson. So here he's recognizing the context, that ultimately all of these cases except for Delaware's were basically a district court denied the plaintiff's motions using the separate but equal doctrine from Plessy. So you get the sense that he's recognizing that up until this point, these cases came to us because before this they had been struck down. I think that's really important because the Supreme Court, if they don't want to rule on something, it just kicks back down to the appellate courts or the district courts. So in this case, they are ruling on something that district courts have already ruled on. So you get a sense that either they're going to affirm that or they're going to throw that precedent out. So here they're taking Plessy on. And Chief Justice Warren is recognizing that in this case, they're specifically focusing on the Equal Protection Clause. And that is that clause in the 14th Amendment that argues that basically all American citizens have equal protection under the laws, regardless of race. And so I think that's something really important here. He also mentions public schools. I think public schools is also important. I feel like one of the questions that will probably end up coming is why not private schools? And the answer is that they're private schools. They are owned by themselves. You pay, tuition. So because it's not run by the government, they can basically allow who they want. Now they can't explicitly discriminate due to that equal protection clause now, but certainly they can find reasons that are not by race. You can't afford it, or you don't live in the area, or whatever it may be. There are ways to sort of obviously allow whoever you want. But in public schools, the idea is that you have equal protection, an equal opportunity to go to them. Now that's obviously the thing that's in question. This ruling is probably going to address that. So I'm going to go on. Under that doctrine, he's talking about Plessy v. Ferguson, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities can be separate. The plaintiffs contend that segregated public schools are not equal and cannot be equal, and that hence they are deprived of the equal protection of the laws. Because of the obvious importance of the question presented, the court took jurisdiction. Argument was heard in 1952 term, and re-argument was heard this term on certain questions propounded by the court. So here he's recognizing that what Plessy says is that as long as there are separate facilities that are equal, then it's allowed. And so obviously the states that passed those laws segregating students said this school for African Americans is just as good, is equal to this school for white students. And he's saying that as long as they are that, then it follows suit. And so he's, again, laying the foundation for understanding what the precedent has been, because the Supreme Court cares a lot about precedent. And so when a Supreme Court has ruled, it's not going to sort of overturn a previous decision lightly. And I think that's the case here, is that he's, Chief Justice Warren is still really thinking about, if he's going to go against this particular case, this particular precedent, he has to be careful about sort of maybe poking at little, or chipping away, cutting away at little pieces of it, rather than just throwing out the whole thing, because that's really hard to do. Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. So he is obviously recognizing something that many of us recognize every day, which is that education is the most important thing. It's the most important function of government, which he recognizes not only due to its sort of foundation of good citizenship, as he says, but also this idea that that we put in laws that make students have to go. We put lots of money into education. So he's recognizing that it's not just that we recognize, that we say that education is important, but we do things in our legislatures to make sure that that's the case too. So he is really, really recognizing here that education is that foundation for good citizenship, and seems to be maybe the most important function of government. He mentions state and local, not federal, which is interesting, that this is a federal court that's ruling on state and local governments' decisions around segregation. And he sort of tips his hat on what direction he's going to go in here at the end, where he says, it is a right which must be made available to all on equal terms. So that sounds like, okay, if Plessy is true, then those two schools have to be equal according to this. And so that, I think, is where he's going to jump down. We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. So he says it's not about the equal facilities. He recognizes that right here. There are tangible factors, he says, that deprive the children of the minority group of equal educational opportunities. So he's saying if these two schools are exactly the same, the fact that they are not actually integrated, that in itself creates that deprivation of equal opportunity. So we're going to see what he says about it. He references, so he says, in McLaurin v. Oklahoma State Regents, Supra, the court, in requiring that a Negro admitted to a white graduate school be treated like all other students, again resorted to intangible considerations. Quote, his ability to study, to engage in discussions and exchange views with other students, and in general to learn his profession. Such considerations apply with added force to children in grade and high schools. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The effect of this separation on their educational opportunities was well stated by the finding in the Kansas case, by a court which nevertheless felt compelled to rule against the Negro children. The impact is greater when it has the sanction of the law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to retard, meaning to sort of slow down or to hinder, the educational and mental development of Negro children, and to deprive them of some of the benefits they would receive in a racially integrated school system. So Warren takes this argument of separate but equal is is equal, is inherently equal, and he completely blows it up. He says that ultimately it generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. I think that is as well said as anything. It's very easy to understand. A sense of inferiority affects the motivation of a child to learn. That if you believe you are stupid, if you believe that you are not as you're in a lower caste, if you don't believe that you are able to succeed in life, that your learning is going to be affected, that your equal education cannot be equal. And he says, he uses that McLaurin v. Oklahoma State Regents argument, as well as the Kansas argument. And he says, even though they ruled against the plaintiffs, they recognized in their argument that that segregation of white and colored children in public schools has a detrimental effect upon the colored children. Obviously, though, the state of Kansas, at least the district court, didn't feel like that was enough. But Warren is really blowing up this argument by saying that it does have an effect, that it doesn't matter if they're separate facilities that are equal, that inherently they're not equal because they are separate. Whatever may have been the extent of psychological knowledge at the time of Plessy v. Ferguson, this finding is amply supported by modern authority. Any language in Plessy v. Ferguson contrary to this finding is rejected. So it's rejected, that ultimately he recognizes that whatever was decided before has been completely destroyed by modern authority, that now times change. And we know the worst type of argument is that, well, that's how it's always been. And ultimately that ends up being the argument that many made, that, well, African Americans are inferior, white supremacy is there for a reason, and so it's just beneficial to all, right? And here he's saying that that's not true, that we now know that this is wrong, that it's wrong. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment. So very clearly he says, yes, the plaintiffs are correct, that the 14th Amendment, under that due process and equal protection clause, absolutely is being violated with these laws, specifically around education. Because these are class actions, because of the wide applicability of this decision, and because of the great variety of local conditions, the formulation of decrees in these cases presents problems of considerable complexity. On re-argument, the consideration of appropriate relief was necessarily subordinated to the primary question, the constitutionality of segregation in public education. We have now announced that such segregation is a denial of the equal protection of the laws. So the end is really important too, because what he is saying, and this was a 9-0 opinion, this was unanimous, which is amazing that basically 60 years before, 58 years before, Plessy v. Ferguson was agreed to. I believe it was, the majority opinion was 7-1, with Justice John Marshall Harlan and the dissent, saying that basically that none of this is true in practice rather than looking at the laws. But it's amazing to think that in 60 years it's completely flipped the other way, that 9-0, the Warren Court specifically, agrees that it's a violation of the 14th Amendment. But one thing I want to be clear on is that this strikes down segregation in public education. That's it. It's very, very clear that we have now announced that such segregation is a denial of the equal protection of the laws. Not all segregation, public education. And so my question to you is, why do you think they don't strike down all of Plessy? Like, why don't just throw it out? Like, why not toss it in the dustbin of history like they did with Dred Scott v. Sanford? Like, why not just trash it? And I asked that question to you guys on Remind, and a couple people who gave really good answers that I wanted to recognize, and maybe you were thinking about this too. I remember, I feel like Ashlyn McKelvey and Jason Sue and Nick Masharikoff were talking about how, which I thought were really good points, that ultimately in this time, for the court to basically throw out the entire case on segregation maybe felt a little bit too much too soon. Jason specifically brought up the idea that Plessy, if you remember, Plessy v. Ferguson was about public transportation, and so there's a way in which maybe Justice Warren and the other justices felt like they had to focus on what this was talking about, which was education itself. It was easier to throw out segregation in education than it was to throw out complete, Jim Crow laws generally. I think those are really good points. I also, I'm just curious about why you think, because, there is something about this idea of segregation that feels like so inherently wrong, and so antithetical to what we sort of believe in as democratic and justice for all in American values. And so I'm really curious as to why you all think that Justice Warren doesn't throw the whole thing out, or rather doesn't throw out segregation totally, because all he really does is rule that segregation in public education is in itself a violation of the 14th Amendment. So Merida